All right. Well, Noah, you're going to turn to some contractual problems.
Right. Now we're going to talk about 4 cases involving contracts and various issues. I think each of these cases have some interesting points, but the only similarity they really share is that contracts are involved. So the first case is Zuma Tex-Mex Grill v. Azumi. Zuma Tex-Mex Grill is a Mexican place in Bifannual, and Azumi operates a chain of high-end Japanese restaurants. They just opened one at the Four Seasons in Back Bay. Zuma had applied for a trademark, which it got, and Azumi, they sought to cancel the registration. Negotiations ensued, and the parties reached a settlement agreement whereby Zuma Tex-Mex Grill transferred its trademark to Azumi for $125,000 for a royalty-free license so that it could operate its restaurant in Boston or maybe even broader New England. And finally, that Azumi would not open a Zuma in Boston. Well, Azumi went ahead and opened one in Boston, triggering this lawsuit. There are a couple interesting things here. First, the Tex-Mex Grill moved for a preliminary injunction, and the court concluded that it was likely to succeed on the merits in light of the settlement agreement. It found that that irreparable harm would result from the denial of the preliminary injunction. As soon as Zuma opened, Zuma Tex-Mex had a lot of issues where customers thought they were making a reservation at Zuma, and they were either canceling or they just weren't showing up. There are also other issues where they were getting called a lot and where people thought that they were the Japanese restaurant. And there are even problems with the bank where there are issues with deposits. So it was clear to the court that there was harm. And then finally, it kind of balanced the harm to the parties and found that, again, the Tex-Mex Grill was most likely to, they were losing in the equities. Interestingly, though, the court highlighted one difference between seeking a preliminary injunction under Massachusetts law versus federal law. Under Massachusetts law, the court doesn't have to consider public policy. It only has to do so where it's appropriate. And here, because the nature of the dispute was really between two parties, it chose not to, analyze the public policy piece. Finally, I want to note that Azumi tried to argue that it provided notice under the settlement agreement. And how it did so was at the end of an incredibly lengthy email, they said, hey, we're going to open a restaurant here in Boston named Zuma. The court concluded that was not sufficient. So, when you're analyzing whether notice is given under a contract, I think it's not just is it in the text of an email or a letter, it's kind of where is it and what is the letter about. The letter was also about something like food inspections. So if somebody was just looking at the subject of this super lengthy email, they wouldn't think that any notice that they were kind of opening a restaurant was in there.
It's worth actually reading the text. This is down at the very bottom of the email, and it says, additionally, as a courtesy, our client wanted to let you know that it'll be opening a Zuma restaurant in Boston. Please let us know if you have any questions about this. That was it. And kind of like the footnote provisions where litigants put them in footnotes, dropping that line as a courtesy that we're going to be violating our agreement. Please let us know if you have any questions is not gonna fly. Although speaking as somebody who lives directly opposite the new Zuma, I'm happy that this worked out because the new Zuma is really very, very good.
All right, so next case is Metal Seal Precision Limited v. Sensata Technologies. The Plaintiff entered into a memorandum of understanding with the defendant whereby the defendant agreed to purchase minimum amounts of sensor products that were used in cars. The defendant refused to purchase that minimum amount, and the plaintiff sued. The defendant argued that never agreed to a minimum purchase amount, or in the alternative, that provision was procured by fraud or a misrepresentation. It filed counterclaims alleging that. And here the court argued that the plaintiff's representations were not actionable because it went to the bargaining position. During negotiations, the plaintiff told the defendant, hey, there has to be minimum purchase requirements because our insurers were requiring it. I guess that wasn't true. However, the court found it wasn't actionable because it didn't go to the amount, the quantity of goods, or quality. This case is kind of interesting because first, there's not a lot of case law in Massachusetts on this topic, and the court focused on decisions from other jurisdictions like Vermont. However, it's interesting in that maybe the plaintiff lied, but because the terms were actually in the contract and the defendant could see them and determine whether they were acceptable, it didn't actually go to a term of the contract, or the statement about the insurer didn't go to a term, it went to bargaining position. And based on that, the court found it was not actionable.
Yeah, and I think this kind of case, comes up, the issue comes up. I'm surprised that there's not a lot of case law on it. When you have a integrated contract, what's the nature of the misstatements that were made in advance of that contract, which will nevertheless be actionable, even though there might be an integration clause? How much difference does it make to have an integration clause? This is, as you say, the facts. It's all about the facts. But in this case, although there may have been a lie, it appears to have been a lie that really didn't go to the substance of the contract, and that the statement that was in the contract itself was clear. I don't know if you must come up, where people are trying to find a way around the contractual terms, and you're looking for something that somebody said sometime before that contract to use as a wedge.
Yep, and the trial version of it, of course, is, wow, the other side did something that's a jury's really going to hate. How do I get this before the jury? Because they're going to hate it. And I think another takeaway from the decision here is reminding us all that you always need to go back to basics, right? Who needs to prove what? What does my side need to prove? How am I going to prove it? What does the other side need to prove? How am I going to muck that up? That's one way of describing a lawsuit, right? And whether it's trying to figure out what statements are material, or whether it's trying to figure out what evidence at trial is admissible, all of that, those kinds of relevance determinations have to be answered through the filter of, well, what's really at issue? What's the claim? What are the defenses? What needs to be proved? And just because you've got some evidence that, wow, they were really lying about this, maybe it doesn't matter. Yes, they were lying that they liked the haircut that you had just gotten, but maybe it doesn't matter. So you've got to tie it to what's really going to have to be decided in the case.
Well, it's also interesting because if I really want to enter into an agreement and somebody tells me that their insurer is requiring something, I might be more likely to accept it even if I don't necessarily have to. Okay. So next case is Headquarters Hotel v. LBV Hotel. Here the plaintiff entered into a state for years agreement with the defendant's predecessor. The agreement contained a right of first offer where if either party to the agreement wanted to sell its interests, it had to give the other side an opportunity to purchase. The defendant, in accordance with the right of first offer provision, reached out to the plaintiff, and in connection with that right of first offer, it sought to get it to enter into a confidentiality provision so that it could conduct due diligence. For whatever reason, and I don't really understand why, however, the plaintiff refused to enter into that confidentiality agreement. When the defendant sent it the agreement, it actually marked it up so that it had the ability to disclose things it learned to third parties. That strikes me as kind of odd. In any way, Headquarters Hotel, they sued, saying that they had accepted the offer, and LBV Hotel actually responded, basically saying that Headquarters Hotel was a rejection of the offer. The BLS agreed, primarily because as part of the offer, the potential seller required all parties to enter into the confidentiality agreement. So the terms were the same regardless of who it was. Also, in the facts, after the court concluded that Headquarters Hotel rejected the offer, it also noted that there was no offer there because LVV validly accepted its common law right to rescind it. So I think this case is interesting for a couple of reasons. First, I think even if you're a potential seller and you're subject to a right of first offer provision, you can kind of impose whatever terms you want for the most part, so long as they're reasonable, as long as it applies to everybody. And then second, you can kind of think of it from the reverse side, so that if you are drafting an agreement with a right of first offer, you might want to put in some terms so that a party cannot necessarily quickly rescind it. So when you're kind of negotiating these agreements, I think you should see if you can play around with it a little. Here, I think the right of first offer provision was fairly vanilla. It didn't impose that many terms on the parties, but I could see a situation where you could draft something that does.
Noah, what was the procedural posture of this case, if you know? Was this a summary judgment decision, or?
No, this wasn't. This was, sorry.
Right, this is summary judgment.
Yes, summary judgment.
Okay. Yeah, because listening to you describe it, it just making me think I'm a little surprised as a judge how often questions of offer and acceptance, it's all in written documents or email, some other form of writing, and can often be resolved by the judge because there's no factual dispute about what the communications were. It's just a question of the legal import of them. It's different from a case, obviously, where part of the allegation was, and then we met over 3 drinks, and really he said, I love it, I'll do it, I'll buy all of my products from you and from nobody else. But if it's really just, maybe it's in the guise of somebody trying to enforce an alleged settlement agreement or some other context. But it's not infrequent where these questions of offer and acceptance can appropriately be teed up and resolved in a motion for summary judgment.
A couple of interesting things about this case, just because I just find it interesting because we live in a city that's got so much history. This particular property is the old Boston police headquarters, which were turned into a hotel by the predecessor to LBV. So the place out right on Park Plaza here. The other part, which I thought was kind of interesting, is that there's the underlying agreement grants the defendant LBV an estate in the real estate for 129 years. And made me think, like the first time I've thought in about 5 years, about the rule against perpetuities. I don't know how far out you can go, but the agreement does provide the date 2131 is the day that the lease comes undone for the property at LBV. What's also a little bit the challenge on a summary judgment record, and even more so on a motion to dismiss record, is what's really some of the other facts, because it does appear that the seller rescinds its offer, but then doesn't offer it to anybody else. It doesn't actually sell the property. And so there must have been evidence in the case that, yes, we really did have that term for everybody else. Otherwise, the argument to be made that this was unique to us and so forth. But they ultimately, maybe market conditions changed or something, but having not gotten what they wanted from Headquarters Hotel, they decide not to sell at all.
Okay, and the last case in this topic is Psychemedics Corporation via City of Boston. Plaintiff Psychemedics Corporation performed hair follicle testing for Boston police officers and recruits. In performing its testing, something like 10 officers tested positive for cocaine and were fired. They sued, and pursuant to the agreement between Psychemedic and the City of Boston, it shall assume the defense of and hold the city, its officers, agents, or employees harmless from all suits and claims against them, or any of them arising from any wrongful or negligent act or omission of Psychemedics, its agents, or employees in any way connected with the performance under this contract. So, in other words, it had to provide a defense and indemnify the city for any claims. A bunch of officers filed suit in 2005, and the city did not act promptly seeking a defense. It waited until around early 2006 and simply asked for financial assistance in responding to the lawsuits. There were subsequent requests which were rejected. In rejecting the city's claim, Psychemedics took the odd position that the indemnification agreement only applied if duty to defend and indemnification only applied if the city were actually found liable. So the case actually, it might still be going. I think one of the cases is under consideration. However, as you can imagine, a substantial amount of money has piled up. So Psychemedics sought a declaration, a declaratory judgment from the court to say that it didn't owe the city of Boston anything. The court agreed because the city of Boston never made an express request that Psychemedics actually assume the defense. Instead, all it did was asked it to contribute money. And the court found that this unilateral assumption of the defense was actually a breach of that agreement. And Psychemedics didn't have to indemnify Boston for anything. In noting this, the court, it said that there's really no kind of magic language where you have to request that a party assume the defense. But because the city of Boston really didn't do anything, it was insufficient to trigger that clause.
And I think that's a practice pointer for us, for our clients. I mean, we often have insurance contracts or we have indemnity agreements where someone has agreed to pick up the cost, the duty to indemnify and to defend. And obviously those are subject to whatever language you've put into your contract. But as a general matter, as a matter of law, if there is a duty to defend, what this case stands for, and citing an 1898 case from the SJC, is that if there's a duty to defend, you must offer the opportunity to the indemnitor to actually assume the defense of the case. And in this particular case, it was, in substance, we'll handle the case and then we'll send the bill to you, and we would like to talk about, divvying up the financial responsibilities. But citing this 1898 case, the court says that's not enough. If there's an actual duty to defend, you have to allow the other party to take over the defense of the case. And I'm sure many of you have had this experience where the client is excited about the fact that its costs and its losses are going to be indemnified, but hell no, I'm not going to let them take over and use their lawyer. I don't trust their lawyer. I want you to be the lawyer, or I want a different lawyer. And unless the language of your contract is changing the basic law here, you really have to watch out, because unless you give that opportunity to the indemnitor, this case says that indemnitor is going to be off the hook.
I think outside the insurance context, where the policy forms are pretty well settled in this area, parties are free to contract around that background law, but it's also a reminder that outside the insurance context, neither party is used to an obligation to defend or indemnify for litigation costs, and so isn't quite sure what they're supposed to do. So if you're counseling at that point in time, be very careful.
Yes, you don't want to, you may have a great right that's worth a lot of money, and as this case appears to demonstrate, fairly subtle differences in the way that you're approaching the obligations of the parties can lead to effectively a forfeiture of the right to obtain that money. We're going to turn now to a couple of cases that involve the equitable jurisdiction of the court. It's been a long time since law and equity have merged, but it actually matters more than one might think, and I'd be interested to hear Judge Salinger's view of this once we talk about the case. But the fact that certain actions are brought at law and certain actions are brought in equity can make a difference in what the ultimate outcome of the case might be. The particular case that I want to start with is this Finnegan case, Finnegan v. Vbenx. Judging from what I see in the case, and I'm probably going to defame him now, but this Brent Finnegan seems like a real character. He got into a battle with this Vbenx corporation in which he was involved. The Vbenx corporation decided that Finnegan was acting in some way improper or committing fraud, and there were a series of trials. Finnegan appears to be somebody who likes to litigate. There were 2 trials. There was an appeal in the appeals court. There was another appeal coming back up. First trial was the jury, then the second one was jury waived. And now, as the case was going up yet again, and it had been found against Finnegan, Finnegan made demand for advancement of his legal fees. He had actually been receiving advancement on his legal fees based on the bylaws and Delaware law that governed the Vbenx corporation. The Vbenx people, having won the trial, sought to use Rule 69 discovery to get in aid of enforcement and in aid of its judgment. And in the course of doing so, it discovered that Mr. Finnegan and his wife had apparently transferred something like $10 million, bought a home in Florida where the laws of homestead are extremely powerful. Effectively, he was committing what they would view as a fraudulent conveyance in moving the money out of Massachusetts and out of the hands of Vbenx, all the while saying, I need my fees advanced from Vbenx. I'm going to be indemnified, and I want an advancement of fees. And as I say, they'd already paid over $1 million in fees. At this point, Vbenx comes in and says, we're sick and tired of advancing our fees to this guy who we think is a crook, where he's just using the money against us, and we're watching as he's taking his assets and spiriting them off to places where we're never going to have them. What's interesting, I think, about the case, and by the way, this is a 25-day trial between Finnegan and Vbenx, so quite a lot of paper, quite a lot of argument, all of which going to some lawyer who's getting advancement of fees through the corporation that is litigating. What I found interesting in the case, and something I never had thought about or known before, is that the court says indemnification is a right at law. It's a contractual right which is recoverable in damages, and as a result, if Mr. Finnegan ultimately should prevail, flip this case, for example, because he had lost, but to flip it on appeal and come back, he should be indemnified for all of his losses, including if he wins, his claims, the claims that Vbenx had brought against him. So that's at law. But advancement of fees is an equitable provision. It's not a contractual one. It is an equitable obligation to make these monies available. And as a result, the court said that the distinction that matters here is that unclean hands is a defense to an equitable action. Unclean hands is not a defense to a straight contract action. We all remember from law school, morality is not supposed to play a role in contract cases. So here the court says, I am not going to order, this is Judge Kaplan, I'm not going to order any further advancement until we have an evidentiary hearing. And that evidentiary hearing is going to be about whether Mr. Finnegan's hands are clean or not in the way that he's handled his assets. And until we determine whether his hands are clean or not, I am not going to order the advancement of fees. So I don't know, I found it to be really a fascinating case about these distinctions that live with us probably now close to 100 years after the merger of law and equity, but it really does have a consequence in the defenses that can be brought.
And don't forget, it has a consequence as to what claims you have a right to get before a jury and which you don't.
That's right. And so on the unclean hands, there was no need for a jury trial on that. The judge could have an evidentiary hearing, make the determination as to whether the hands are clean or not, and ultimately conclude, well, we don't know what's going to be concluded. I don't know whether we don't know whether there's any further. This is from February 6, 2019. One thinks that probably something happened in the meantime, but we don't know. So in any event, I think just one of those cases that kind of pulls us back into law school and some fundamental principles that sometimes we might think have disappeared. The second case in terms of equity that I wanted to talk about was a case called Elements Production versus Editbar. And the first question I have is actually for Judge Salinger, because Judge Davis renders his opinion and indicates in his opinion that for the first time, rather than sit down and write the thing, I am going to read it. And he says, if I had to write it, you aren't going to get an opinion for another 6 months. So instead, I've laid things in an outline, and I'm going to read it into the record, and that's going to be the decision. I know Judge Woodlock, for example, quite frequently does that in the federal court. What are your approach to spoken decisions as opposed to written ones?
I've been doing that with more regularity in the BLS when I have presided over a bench trial, and for some reason I can't fathom, people are not satisfied with me answering special questions but want me to make detailed findings of fact. My general practice on that is to bring people back into court some period of time later, work off an outline and dictate my findings and rulings rather than try to write it up. I've done it on the criminal side with more frequency, make factual findings on motion to suppress hearings, on dangerousness hearings, things like that. Generally, with BLS motion decisions, my practice has been, if I can sort of decide it from the bench at the time of hearing, I'll explain the decision, and I might just endorse the motion as allowed or denied for the reasons stated on the record. And if it needs more than that and it's not making findings after an evidentiary hearing, I've tended to write it up. But having the option of doing a spoken decision can sometimes speed things up, and good to see that Judge Davis is experimenting with that as well.
Let me ask, as a practical matter, because the courts have been obviously everything is more expensive. What about court reporters? Does it matter whether the parties have paid for the court reporter and therefore it's going to be transcribed quickly, or how do you handle the question of getting the transcription soon?
So that also depends on context. If it's a case where it's a well-funded BLS matter and the parties have not paid for a court reporter, it seems to me if somebody wants something transcribed, they know how to get it from the Office of Transcription Services, which turns things around reasonably quickly, and the transcripts are really quite good. So it would be unusual for me if I were making findings on the record or rulings on the record for me to just order that it be transcribed and put in the file. I would generally leave it to the parties if they want it because they want to show it to their clients, if they want it because they want to figure out what part of it they're going to appeal first, they know how to get a transcript.
So the case itself, I think, is an interesting one, again, because it involves this issue of law and equity. It's a case, it goes on for quite some time, but the basic point is that Mr. Hankey, the defendant and third-party plaintiff, is an employee of Element Productions, which is they do high-end videos. And Hankey has friends who are starting their own production company, and for about a year, while Hankey is working for Element Productions, he basically siphons off projects to his friends so that they can start the Stir Films, which is also known as Sweet Ricky. And ultimately, the company finds out about it, that he's been siphoning off these to help his friend make a series of productions, and brings a lawsuit claiming that, among other things, it's a breach of fiduciary duty, brings contract claims and other things. And there are a number of interesting holdings in the case that we can talk about, among them the fact that Hankey, as a senior executive, as an executive in this company, does indeed have a fiduciary duty not to be sending corporate opportunities to friends, whether or not they have a non-solicitation or a non-competition agreement, that there's a fundamental fiduciary duty to your employer not to be doing that sort of thing. But what becomes sort of interesting in the case, and if you were reading it kind of as a novel, you would read it, and things seem to be going very, very well for Element, as they find. Judge Davis finds that this was a violation of contract, and it's a violation of his fiduciary duties, and it seems like Mr. Hankey is in real trouble. But then Judge Davis gets to the question of damages, and says that when he looks at the damages that are claimed by Element, they have focused on the productions that were sent by Mr. Hankey to this other company. Element has brought in an expert, somebody that you know and I know, and who comes in and talks about the value of these properties, but the facts that he needed to, the judge actually says, I don't feel that the expert did anything wrong. The problem was that the assumptions for the expert opinion weren't there, which is that these productions, the likelihood of success of productions coming out in the first place is very low, and these particular types of productions were very, very unlikely. They did not establish that Element would ever have succeeded in making these successful, so that there were not, that saying that there were damages that Mr. Hankey's actions caused and that they were worth millions was completely speculative. And so the court finds, as a matter of legal damages, so at-law damages, that there aren't any. That nothing that Mr. Hankey did actually caused harm to Element, which did very well and continued to operate, and so forth. So then the court needs to go on, though, and again, the issue of law and equity comes up several times. The court says that it's not only damages that could be awarded. In a case like this, where there's been a breach of fiduciary duty, Mr. Hankey was paid. He was paid by the company for doing his job. And the court looks to whether Mr. Hankey did his job the way he was supposed to, and of course he didn't. He was siphoning these projects off to his friends. So not as an element of damages, but rather as an element of restitution, an equitable remedy. The court does, and again, not with a jury because it's an equitable remedy, the court looks at it and says, okay, I'm going to have to make kind of some rough justice about how much of Mr. Hankey's salary really should go back to the company. Not because it was damaged, but because Mr. Hankey was unjustly enriched by having that money paid to him, and the company really should have it back. And so that's what he orders. He basically orders that half of Mr. Hankey's salary and bonuses, he was a fairly well-paid man, it comes to something like $600,000. But the story doesn't end there. So that's the equitable decision that the court makes. Then Mr. Hankey comes back and says, well, you settled with Sweet Ricky and whatever, these other companies, and they paid $300,000. And I'm claiming under the joint tortfeasors contribution statute that I should get the credit for the amount of money that was paid in settlement. I should get I should get an offset. I shouldn't have to pay the full amount of the $600,000. And Judge Davis examines this again and says, you're talking about two different things. What the settlement was about was the legal claim that these people violated the law, and these are damages that are being paid for the losses that Element claimed, even though evidently it found out later that there weren't any damages. But the compensation that was paid from Mr. Hankey to the company was restitution, and that those two things are not commensurable in the contribution joint tortfeasor statute, and therefore Mr. Hankey, notwithstanding the $300,000 had been paid by the other joint tortfeasor, he was still going to have to pay the full $600 and something thousand. Again, fundamental principles that we kind of learned in law school about the differences between a legal claim, an equitable claim, a legal remedy, and an equitable remedy have led to Mr. Hankey, on one hand, because the legal claim had to be supported as damages, he didn't have to pay some large amount of damages that was claimed. On the other hand, he did have to pay restitution for his unjust enrichment.
Equity lives.
Equity lives. Those are words to live by. So those are two cases that, again, just as a reminder that this court acts both at law and as a chancellor in equity. And then we have a couple of odds and ends that we thought we would talk about just to finish up. Noah, you want to take it from there?
Yeah, of course. So these are just kind of quick decisions that you can use and provide pretty nice analyses. First one is Federal Home Loan Bank of Boston v. Ally Financial. This case arises out of the mortgage crisis in 2007, 2008. The plaintiff alleged that various defendants made various misrepresentations in the offering documents, causing it harm. Interestingly here, with respect to one defendant, it sponsored 6 instruments. The plaintiff bought 4 of them directly from the defendant, and they bought the other 2 from Bear Stearns. So with respect to the negligent misrepresentation claim, there was a potential issue because, Federal Home Bank of Boston obviously is based here. However, Nomura and Bear Stearns are based in New York. So under New York law, parties cannot bring a claim for negligent misrepresentation unless they're in privity. So with respect to the securities that the plaintiff bought from Bear Stearns but were sponsored by Nomura, there was no privity. However, there's not that requirement under Massachusetts law. The parties do not need to be in privity for a negligent misrepresentation claim. So the court, I think here it did like a pretty nice analysis under the restatement of laws. It started with section 148, subsection 2, which provides the following factors that a court needs to look at when it's determining which jurisdiction has the most significant relationship for purposes of choice of law. So it looks at the place or places where the plaintiff acted in reliance upon the defendant's representations, the place where the defendant received the representations, the place where the defendant made the representations, the domicile, resident, nationality, place of incorporation, and the place of business of the parties. So that was the starting point. Now, what informs its analysis in placing weight on the factors is actually section 6 of the restatement, which provides for general principles. So things to look at are the needs of the interstate and international systems, the relevant policies of the forum, the relevant policies of other interested states, and the relative interests of those states in the determination of the particular issue, the protection of justified expectations, the basic policies underlying the particular field of law, certainty, predictability, and this one's important, and uniformity of the result, and finally, ease in the determination application of law to be applied. So that was the starting point. What the defendants tried to do, however, is they started with those general principles, and they said that it was important that there's uniformity of law, and therefore New York law should apply. The BLS here said no, the starting point is 148, and more importantly, that factor for uniformity, there was a question as to how much weight should be placed on it. So in light of those principles, because actions were directed at Massachusetts to get the Federal Home Bank to purchase those securities, and it was based here, the court concluded that Massachusetts law should apply and allowed the negligent misrepresentation claim.
Can I ask you, just as a practical matter, you get these cases, the word comes down from the SJC that you are to use a multifactorial approach, 8 different factors, et cetera, et cetera. do you have a thought in your mind or sort of a plan as to how do you work through those factors and think through, okay, well, now we're here, now we're here. What is your thought process when you've got one of these, a situation like this?
I think it's a great question. I think different judges approach it differently. I think there are some judges, you can see it in their decisions, hey, the SJC said it's an 8-factor test, I better analyze all 8 factors. I tend to come at it differently. I tend to say, okay, here are the things that are relevant. Let me make sense of the facts of this case. Of those factors, what matters here? And maybe I'll say, some of the factors aren't even implicated. Maybe I won't bother, but I will use the multi-factor test to sort of focus the analysis. But I think I'm in the camp of those tests that say, consider all these things, and then let us know what you come up with. Is a different rule of law than other kinds, and I approach it differently.
And when we as litigants, having something like this, what would be, I know you're only one of 4 BLS judges, but what's the best way to kind of appeal to you on these multi-factor tests? Is it to go through all 8 factors, or is it to say, Judge, really what matters here, what should matter, or the dominant factor is 1, 2, and 5, those are really at play in this case, and let me talk about those?
I personally would find that most useful, and I have no idea how small a minority I represent in saying that. The other thing that occurs to me, this is a case, like many cases in the BLS, where the parties explicitly teed up a choice of law issue for the judge to decide. I think there are too many cases where lawyers either haven't given enough thought to or just haven't been clear enough with the judge about choice of law, even if it's not an issue and it's obvious. Sometimes in a business dispute in the BLS, it's worth saying, oh, Judge, yeah, this contract says it's governed by Massachusetts law. Great, everybody's on board with that. Or this is, a internal dispute about a Delaware limited liability company, and so Delaware's law is going to govern. Great. If you are contending that something is governed by the law of some jurisdiction other than Massachusetts, and also that it makes a difference, because often it makes no difference at all, so who cares? It's really important that you raise that loud and clear at the outset. I am cringing a little bit thinking back to the bench trial I presided over a few years back, where after weeks of evidence, and then I at that point was still writing up all of my findings and rulings on the motion for reconsideration, one of the parties said, well, Judge, actually, this issue is governed by New York law, and here's why, and New York law is different than Massachusetts law on this point. It didn't actually affect the outcome, my decision, but it would have been useful to know that was the position of a party before that point in the case. So do give it some thought. It occurs to me, look, if those of you who do appellate work on the federal side, you're used to the federal rule, which I think is still there. I haven't been an appellate lawyer for a few years. You have to explicitly explain why the court has jurisdiction. We don't have a rule that says you must all the time say what jurisdiction's law governs, but in many BLS cases, it really is worth not only thinking it through, but making it explicit for the judge, and then you'll find out if the other side disagrees.
So I think in the interest of time, it's 10 of 6, and these are some odds and ends. I will just say that the last case that is in here, just for those who increasingly we do see cases under the False Claims Act, and there are False Claims Act cases, statutes, in every state now, I believe every state. This one stands for the proposition that, not surprisingly, the laws of the federal False Claims Act, to the extent that there isn't anything in Massachusetts jurisprudence, will apply in analyzing a Massachusetts False Claims Act case, and we may see more of those cases being brought as we go forward. So I thought we would, I don't know if you have any parting words or parting thoughts, or whether we just open the floor to any questions that people may have for Judge Salinger, who actually knows what he's talking about, or Noah and I, who will vamp. Can't be possible. If not, then we'll call it a day, but we thank everybody for coming. We thank Judge Salinger for taking the time to be with us to talk about these cases. Obviously, a lot of interesting stuff going on in the BLS, and I'm sure with a new judge, Judge Green, we'll have some new jurisprudence as well, and we thank everybody for coming.